Hey, right, guys, just bear with us whilst everyone joins in. You right, Shannon? How's it going?
Evening.
Hey, right, Will, you good? Can't hear you yet, mate. Just give it a minute. So once again, you're going to watch me wrestling with technology this week and probably making a fool of myself. Not as bad as today because I was delivering training on Teams and I hate Teams and I accidentally left the meeting twice and had to kind of be let back in to my own training. So let's see how we get on. So welcome everyone. Usual blurb. Please don't share personal data in the live stream, in the live chat. Just ask questions as if they're about someone else. Uh, that way you get the same answer, but you don't have to put your personal stuff all over the internet. And also, just to say, this is not legal advice. So we're doing our best here, but it's not something you want to go and quote without checking out the source material, which is what we'll try and quote as much as we can in terms of giving citations and stuff. If you're a regular, hello, say hello. It's good to see everyone. You're out there, Western Goddess. Nice to have you here. If you're new, as I say, we're going to spend the next hour or so going through a bunch of questions that have either been submitted during the week in one of the video comment section or in the live stream itself. And so far, I've not had anyone complain about the way we've been doing it the last few weeks in terms of having it, of sharing a Word document and just kind of having the questions up and running. So it seems to be working all right, and I'm hoping it gives an opportunity for people to actually look at what questions we've asked during an evening. So we're going to do it again tonight. What else do I need to say? Oh yeah, if you want to just like the video, I might say that a few times actually, just throughout the stream, just to see if it makes a difference. So if you want to like the video, if you haven't subscribed already to the channel, it's not a bad idea because you'll get updates of when new videos go up and running. So I've got a few in the pipeline actually. A lot of it's just me reading out the code of guidance, but that's another issue. So yeah, let's get back to my screen. And once again, I'm going to say that I really do need another monitor. But anyway, right. So here we go. Questions that we've had so far. Question one, and all of these are quite a mouthful, so I'm going to try my best to make sense of it all. So the housing officer assessed my friend as homeless, and he was given relief duty at the first meeting before the Section 21 expired. So first question, was that right or a mistake? Now, I would say on the surface of that, that looks like it was a mistake because I think what should have happened is they should have accepted the prevention duty at that stage. Now, it might actually be a really diligent officer, and they've actually noticed that although the notice hasn't expired yet, it might be that you're homeless for another reason. This person might be homeless for another reason. So, for example, it might be they can't afford their rent, or it's not suitable for another reason or something. So it's not definitely wrong, but it's potentially a mistake. So that's our first issue. More than 56 days have elapsed, but no communication from the council. Housing officer is blanking them. And in the meanwhile, the Section 21 notice to quit. I think technically I've got some feedback in one of the comments. It's not a notice to quit. It's like a notice for seeking possession. But again, we all know what we mean here. Has expired. My friend was waiting to receive the court papers as he was told to stay put and wait for court since he prefers to approach council. He's now received accelerated procedure claims for possession court papers. Is it legal if the council says the main duty can be accepted only after court? Local charities and advisors have all said that this is what the council do without challenging or questioning it. So yeah, so the local charities might just be basically colluding with this potentially unlawful advice. So interesting question. I'm just trying to work out if we stop here just to kind of answer what we've had so far. Yeah, in fact, I'll go a bit further. So that would mean months spent on relief duty and not 56 days. My friend doesn't even know if he's been considered priority need, despite receiving higher PIP, or if he's waiting for the bailiffs. The council won't help him anyway. If they decide he is not in priority need. He was already on the social housing list before Section 21, but the council said it won't reassess his ban as homeless until after court. So even bidding doesn't make much sense until then. Any advice would be greatly appreciated. So really good questions. I appreciate it's a long one, but it's good set of questions here. And so we'll try and unpick it as best we can. So as I say, I'm hoping I've already answered the question about the relief duty being accepted at the wrong point. However, it sounds as though, although it should have initially been the prevention duty, now that the notice has expired, it should now be the relief duty. Now we've done, in fact, I don't know how easy it is for Shannon to do this whilst I'm juggling screens, but on the YouTube channel, maybe
I'll
three or
link it
four.
in.
Yeah, cool. So I did a full video about this issue, so that's going to answer some of it. So rather than kind of go over that again here, check out the video. It's called Section 21's bailiffs and something or other. I can't remember exactly, but I go through what the code of guidance says about this issue. So the short answer is council should not basically expect people to wait past the date that the Section 21 expires, and they certainly shouldn't be waiting until the bailiff gets anywhere near them, unless the tenant wants to, and there would be some situations where the tenant would want to. So, in terms of this question, can the main duty be accepted before court? Then, yeah, technically it should do so, because basically, if you accept that you're homeless when the Section 21 notice expires, the relief duty kicks in. So you've got 56 days on the relief duty. Then on day 57, and if you search in the Homelessness Code of Guidance for the term day 57, you'll get the paragraph. I can't remember which one it is. The council would then be in a position to reach a final decision. However, in that relief period as well, it would be open to them to make a final accommodation offer or a final Part 6 offer, which kind of mirror the main housing duty anyway, with a little bit watered down. So I think, to say that they can't make a main housing decision or kind of that Section 184 decision before court happens, whatever that means, that would not be lawful. As Will's done a video on his channel recently, is it up and running yet, Will?
No, it's not, unfortunately.
It's good to go. I've seen it. It's good. Yeah. Well, so at some point Will's going to put that out there, but it goes through the timings, because it could take many months to actually get that far. So that's, again, Shannon and will add into this, but that's certainly my answer on that bit. So you can't just blanket say we can't make a main housing duty decision until courts happen, because that's not true. And it does sound likely that the person would be in priority need if they're receiving high rate PIP, but it's not guaranteed. So, again, we've kind of done quite a lot of stuff on vulnerability, and there's no kind of one size fits all kind of definition. But if someone's getting high rate PIP, you would expect that they've got some pretty significant issues, which are highly likely going to deteriorate if that person became homeless and lead to harm that a healthy and robust person wouldn't suffer. And that is, in a sense, the definition of priority needs. So, I'll leave it there. There is another element to it. But Will and Shannon, have I missed anything? Have I got anything wrong? Do you want to add anything in here?
I think the only thing I have to add is sometimes we've had this question or similar question before, but they've included the fact that the local authority is going to pay for court costs, and they're going to pay for, those additional costs that happen throughout this process. And in one sense, that's almost a solution for that person then, because they're like, actually, I'll stay in my home for a bit longer. I'm not going to sort of pay the price for that when, legally, like you say, they don't have to. And so that would be a concern if I was working with this person as well, is actually, are they liable for the cost, and having that conversation with the council and potentially challenging in that way. I'd also, depending on the relationship, be complaining with those charities and advisors. It doesn't seem like they've given good advice, to not even question it. But if it's their job to be sort of advising on housing issues and legal issues, they should know what the council is doing here is unlawful. And I think that warrants a complaint, to be honest.
Yeah.
So I think in regards to the PIP stuff, the only advice I'd give is try and get a copy of the assessment already. So if you need to sort of argue that priority need, try and get all the medical evidence in advance, crucially how it affects you. Things like, highlighting that you have a disability. Because even just by actually highlighting that you have a disability to the local authority, they might suddenly backtrack and go, okay, here's temporary accommodation. You are in priority need, this, and sort of set that ball rolling potentially. It obviously does depend on the local authority, but it has a lot of weight, doesn't it? So that's all I really wanted to add.
Yeah, cool. Nice one. Thanks, Shannon. Yeah, good stuff. Will, do you want to add anything at all to this one?
Well, no, I mean, the thing that occurs to me on this one, apart from there's a number of different sort of legal issues, but in the background to this is a common theme, I think, which is just the lack of communication or the difficulty in getting a straight answer out of people or the council and knowing where you stand. Which is like this thing about not knowing whether you're in priority need. It suggests, I mean, I suppose they're going to play poker on that one and say, well, we don't know, we'll have to do an assessment or something. But it's just adds to the sort of existing stress, doesn't it? If you can't get a straight answer out of anybody, or or get somebody to actually give you some constructive advice, because everybody seems to be just accepting the system's almost broken down in this situation here. So
Yeah.
that's just my observation. And I'd add to that. I don't want to sort of go on a sidetrack, but I've noticed that, I don't know if people in the comments could comment on this, and you guys, but a lot of local authorities now seem to have gone away from the idea of having a homeless persons unit where you could go to, and like in the old days before COVID or whenever, you could go, there'd be a place somewhere in the council where you could go and sit there. You might have to sit there all day, literally, but eventually somebody would come out and talk to you, and you could ask what was going on. Whereas now I had another message. I know that Waltham Forest do this, and I had a message from somebody at Enfield saying that they would meet the applicant at at a particular library. Have you come across this?
I've seen evidence of it. I think
Yeah.
basically councils have thought, well, do you know what, we can cut down on office costs by not having an office, and then kind of work out their library,
Well,
whatever, as a way of kind of
also
saving a
they
bit of money.
get rid of the idea of having to actually interact with homeless applicants adequately, because it was one of the reassuring things you could say to people in the old days: go down to the council's office, you may have to wait, but ask what's going on, ask to speak to a manager, and at least there you would be able to get some answers. Well, it was easier. I'm not saying everybody was sort of giving you lots of time when you went there before, but it's a frightening thing, because presumably if they meet you in the library, they don't stick around in the library, they just come for one appointment there. So if you want to actually see somebody without an appointment, you're stuck. And then when you try and phone them, it's sort of caller center business, and the person's not there. So it's really it's something I think we ought to highlight. I think we should be calling it out when we see it, that they should be having a place where people can go at the council and actually get answers or speak to staff. So that's the end of my
Yeah, no, I
contribution.
can't think of anything in the code of guidance which says there needs to be an office. Like it does say about face-to-face meetings, and if you ask for a face-to-face meeting, you should get one. And actually, interestingly, the Andy Gale advice that Bedford Borough Council got recently, which we've referenced elsewhere, actually said, they want to be doing face-to-face meetings, because I think Andy Gale saying, oh, you can catch people out if they're not in priority need or something. So it's an interesting how different councils are approaching that issue. But I think after COVID, they realised, oh, we can save a bit of money here by not not having that infrastructure, would be my guess. But interesting to see if anyone from the comments kind of adds anything into that.
Yeah, I'd be interested to see.
So actually one person's just saying this. So Banbury, that they allow people just to turn up. So I think my guess is it's probably London councils that are kind of pursuing that kind of strategy. Cool. So and then there's a final element to the question before I forget. So he was already on the social housing list before the Section 21, but the council said it won't reassess his band as homeless until after court. So even bidding doesn't make much sense until then. Any advice would be greatly appreciated. So, I mean, I'd say it would depend on which band this person's on already. But if they're on a relatively high band, then they should absolutely still bid. If there's a realistic chance of winning a bid, then then that might actually happen before the council ever actually get to making a decision anyway. But certainly, I guess another thing, it's going to vary between councils. One thing that might happen is, because the prevention, at the very least, the prevention duty has been accepted. I know they've kind of said they've accepted the relief duty, which might even be better. But generally speaking, even just being under the relief duty with a housing allocation policy, you would get a higher banding anyway. So again, if you Google, I mean, we don't know what council this is about, but if you Google the council's name and housing allocation scheme, and then in that document, it's often a PDF, just search for the term relief duty, you might find that it references it in the banding. So again, if they're saying, oh, we can't do anything until after court, that's, again, it's just a blanket bit of laziness. It's not true. They should be reassessing. If their policy says people under relief duty should be band B or something, then you can, you essentially, you can ask, well, you can complain if you don't get it. So I think in one sense, I'm hoping we've kind of picked apart that in a reasonably helpful way. I think the long and short of it is that you just need to complain. You need to complain that, first of all, the wrong duty was accepted at the wrong point, although it didn't actually do any injustice at that point, but it's still stupid they got it wrong. But the fact that the 56 days has now elapsed, that is a failure that matters. The fact that they've told you that they can't do anything until after court, that's also a failure that the LGO would be interested in it when it gets that far. And the fact that they told you that they can't reassess your banding until after court, again, that kind of would probably be unlawful, but it just depends on the local policy. So, so I think yeah, complaining to the council, as we always say, copying the relevant politicians. So find out who your local councillors are, find out which councillors cover housing, and kind of copy them into that complaint and send it to the chief exec. Don't send it to the complaints team. It will end up with the complaints team, but send it first to the chief exec, because they kind of tend to be a bit more sensible. So yeah, hopefully that's the first question done. Question 2. I don't like it there. Hold on. There we go. So this one here. So a friend is in their 50s, depression, anxiety, suicidal ideation. They were sofa surfing and made unintentionally homeless. First 2 weeks, Lambeth did not provide emergency accommodation and he ended up paying for accommodation. Or sorry, I ended up paying for the accommodation for the friends. I can't quite see my whole screen here. He was then placed in emergency accommodation for 4 days, and on the 4th day, he was advised that temporary accommodation had been sought out of the borough of Bromley, which is Kent. Will, you might help us out. Us non-Londoners don't know where things are, but yeah, I think
Bromley's south east London. It's almost the very edge of London. It is really. I mean, because if you're on the outside of Bromley, you really are not in London. You're sort of on the M25.
Which makes me and Shannon laugh, because we think anything anywhere near the M25 is definitely London, and it's all London and it's all the same. But yeah, I appreciate it's not. In Bromley, he'd been given a unit in a converted house, so studio, no microwave, communal kitchen, away from support network, hospital, doctor. Is claiming universal credit, has no savings, no family, trying to claim rent payments, and Lambeth are already writing for payments. They wanted rent 1 week in advance, but he was told until the move that he was going to Bromley. I'm not sure if I just read that right, but 56-day duty come to an end in about 10 days and still unable to log on to housing options. Lambeth advised not eligible for housing list. He was advised he was eligible for help and unintentionally homeless. I can only presume he's in priority need on health conditions and case law associated. He is alone, getting deeply depressed, feeling more suicidal, unable to afford to travel to hospital. He has been plucked out of Lambeth and placed into a dead-end location, middle of nowhere. So, yeah, not an uncommon situation again, this kind of situation. So I think, I'm not quite sure how you guys might have a better idea of how to approach this. I think in one sense, the hospital and the health stuff is a priority, and you probably don't want to wait to get Lambeth to follow the law before you get the health stuff sorted out. So potentially looking to register at a local GP as disruptive as that can be, if there are kind of current health issues, because he says it needs to go to hospital, and kind of try and get that up and running. However, I would certainly again be complaining to Lambeth Council. I'm sure we had this. So why our case was Lambeth, and I'm pretty sure Lambeth have a policy which say that people shouldn't be placed more than 45 or some distance from the parish boundary. I might just try and Google that whilst someone else is talking to see about that. But there might be a Lambeth specific policy which exists, which would kind of say that's not lawful anyway. But yeah, I think then I'll just be complaining to Lambeth Council again, chief exec again, copying in relevant councillors and just raising this as an issue and kind of explaining why it's so important this person is not kind of placed in the middle of nowhere. So as I say, that's my answer, but Shannon and Will, feel free to chip in. I'm just going to try and find that why our policy thing. So if I can dig it out, I'll share it.
Shannon, do you want to jump in?
Well, I'm confused, which is normal, I guess, but the asking for the rent 1 week in advance seems really odd to me, because with temporary accommodation and with housing benefits that would pay for someone's temporary accommodation, that's always paid sort of in arrears. So you're always sort of behind, as it were, with that system. So asking for it in advance almost makes it, and then the fact that he can't log on to housing options, I'd be doing a subject access request immediately and trying to work out what they're actually considering, what they've actually accepted, what they're actually doing, because although this person clearly knows, you know, roughly what they're talking about, and they're talking about priority need and case law and unintentionally homeless, and it does seem like they've done a good amount of research, I think whatever the council is doing, which seems to be very little, the only way to sort of really understand that is to do a subject access request, request all the documents, and then work from there and see, you know, why are they not on the housing register, the housing options sort of system? Is it because there's a bit of paperwork that hasn't been uploaded? Is it because of whatever? And I think, again, Mike's probably right about focusing on the health issues, and using that in a challenge to the local authority around the unsuitability of location of the temporary accommodation. But Will, I know you've challenged the sort of location of temporary accommodations and stuff before, and it's quite difficult for a layman, particularly to do. So yeah,
it is. And what I would add to that is, and I've been looking into this since last week's session. I was rereading a law report on a case called Parrot. Sounds like parrots, but with an E. And that was all about the relief duty and when you could say that you discharged the relief duty and the need to make a proper personal housing plan and assessment. And it's kind of important here because the question that anyone would ask who's trying to help is what is his bottom line in terms of what is suitable accommodation for somebody in his situation. And the council will normally sort of say, well, Bromley, I mean, to me, I mean, I live around here, but Bromley, compared to Lambeth, isn't really the middle of nowhere because it's sort of next door. It's almost next door borough. I mean, I think they meet at Crystal Palace. Sorry, but so you'd have to go through a list of things, and the council should be doing this, of course, as part of the housing needs assessment, because the housing needs assessment should assess how somebody became homeless, what sort of accommodation they need, and what support they need in living there. Excuse me, and oh, I lost your screen there.
Yeah, no. So I'm just trying to line something up, Will. So keep going. I've got something for you.
So one of the things you can complain about, I mean, I think there should be complaints here as well. And Lambeth does have a complaints website or page on its website, which is quite well attended to. So if you make a complaint and say, I don't know why I can't access the bidding thing or housing options, then there should be a response to that. But also he should ask for a copy of his personal housing plan and also a copy of the housing needs assessment report. Whether the council have drawn up an assessment report is a lot of councils don't do it because they say, well, we don't really need to do it because that's what we do as part of our process. It's a rolling process. And they've sort of been able to get away with that a bit, but there should be a proper personal housing plan. And if you look at most people's personal housing plans, they're pretty useless. But the council, I got one today for somebody, and it just said sort of the council will help you look for local private sector accommodation, but that's basically just encouraging you to do it yourself. So make a complaint about the issues of poor communication again there, of not knowing what's going on, and then complain about the suitability of the accommodation and also the fact that it probably follows an inadequate assessment of his need.
Wonder just about what you were saying there about sort of the assessments and stuff, whether it'd almost be worth asking for a referral to social care and getting a Care Act assessment. Is it Section 42 assessment? Because it sounds like he might have sort of that care and support needs, and potentially that might affect his housing. So getting an in-depth assessment by social might also assist with the housing, and again, just build up that evidence base.
And I think just on that point, so I think if this friend is concerned about them, actually they could also raise a safeguarding alert for self-neglect if if they think they're kind of their well-being's in danger. So I have just found Lambeth's policy, and once again, Zoom is not helping me out here by showing me all the screens that I need to share. But so let me find it. I will find it. So not that one. Hold on. it's up here somewhere. So basically, because I remember from the YR case, which we've talked about before, they mentioned the fact that although all this other illegal stuff as well with the decision, but the Lambeth itself had a policy. And here it is. So here's the policy. It's called Housing Placements Policy. I've literally, this is the first time I've ever seen it. So you might just want to put the link into the chat as well. Basically, I've just kind of gone through it. So prioritisation. So Group A, temporary accommodation will in the borough of Lambeth. So you've got people subject to child protection, households containing one child with a statement of special educational needs, and then households with significant disabilities or medical needs, including mental health, where their health or welfare may be significantly adversely affected by moving out of the borough, as assessed by the council's housing medical advisor. Now, my fear would be that the council's housing medical advisor is actually now medical, who my opinion of couldn't be much lower. But anyway, so for example, this may include the applicant needs to live in a particular locality to give or receive care. The applicant is in receipt of significant care package or receiving specialist healthcare that cannot be transferred elsewhere, or the applicant has a severe and enduring mental health problem where a transfer of care would severely impact on the ability to engage with treatment. So I'd say potentially some of those might apply, but then you've got this Group B, which is temporary accommodation within the local area, which means in the adjacent boroughs or within approximately 30 minutes travelling time. So again, you've got some child kind of stuff, schools and whatever. And again, so basically the person who's asked the question, I suggest you just read through this because you might well be able to kind of, so in fact, if we go here, so or in receipt of DLA or PIP. So again, I don't know, unless I've just conflated the PIP being in this case, and rather than the other one, that might also apply. So I'd say actually look through this, through the policy, and so that you can potentially form your complaint on this and say, do you know what, as well as everything else that Shannon and Will have just suggested, you've also, Lambeth's actually also in breach of their own policy. Now, I don't think that most councils have a policy like this, but the fact that Lambeth does might be useful in this situation. So yeah, hopefully there's some helpful stuff in amongst that, what we've just said. And then the final question we've had that's coming through the week. So again, I'm just going to realign this when Zoom lets me. It's not letting me at the moment, so we're just going to have to deal with it. So can someone who is working but struggling financially and suffering mental health issues be eligible for social housing, property and support from the council? The only support they offered was £850 for a deposit. When I find a room which wouldn't even be near my place of work, and support from them for 56 days. So I think I'm guessing they're the relief duty. My issue is that they didn't even support me because I never heard from them once, and this is why I'm making a complaint, because during my time I've gone from bad to worse mentally. But I would like to learn more about this and whether it's worth carrying through with the complaint and best way to do so, if that's the best course to take, but also what support they should be offering. But the main question is whether I'm entitled to support regardless of my employment status, the level of support I'm entitled to. I know vulnerability is a factor. Would this be considered for someone working? I've told the council about my risk of losing my job due to homelessness. So it's my guess here, I'm speculating what's happened here is that this person is in work, and although they might in reality have some difficulties around mental health, the council probably saw that they are in work, said, oh, you must be fine, then you can't possibly be in priority need because you're working, which is absurd, but that's how some officers think. And then effectively they've just gone through the motions, because remember, unless you're in priority needs, the council doesn't have to really do anything. We have to. They should do some stuff, but they don't have to. They certainly don't have to provide you with accommodation. They just have to try and help you to find accommodation, which is it's difficult to argue with. Really, it's very kind of flexible how they would engage with that. So my guess is that's essentially what's happened. They've made a homeless application. The council has offered £850 for a deposit for accommodation, which is part of the help they're giving to help you find accommodation, but that hasn't worked out. The 56-day period has ended, and they've therefore washed their hands of this applicant. So with the relief duty, if you're homeless but you're not in priority need, the council can make some noise about trying to help you out, but when the 56-day period finishes, that's the end of it. They don't have to do anything else, and I think that's what's happened here. So what you could do, what I'd be doing here is, if I was working with someone in this situation, is I'd be advising them to go and engage with their GP to kind of get an up-to-date diagnosis of their health. And the GP might be able to make referrals to support services and so on to actually help the person with their mental health. And then I'd be making a fresh homeless application, and and try see if there's an argument to be made for vulnerability. Again, the threshold for vulnerability is not as high as a lot of council, well, as high as most councils think it is. But again, if you had, let's say you had relatively low level mental health issues and the GP was to say, yeah, do you know what, treatment's working fine, the antidepressants are working fine, I've got no concerns, then the council might legitimately be able to reach a non-priority decision. And again, you're back to square one. So that's my answer to this question. I don't know if you guys want to add anything to that.
I don't know if I'd approach it that way, or whether it'd almost be worth triggering a fresh application. And that's not to say complaining about this decision potentially isn't the wrong thing to do, but I wonder if a fresh application with new information about the fact that your mental health has gotten worse because of the situation deteriorating, because of your financial situation deteriorating, because of your mental health situation deteriorating, and making a fresh application, starting from the beginning. And that way, it sort of gives you a little bit more breathing space to really lay out sort of that legal vulnerability test almost, and say, look, nowhere in the case law does it say if I'm working, I'm suddenly not in priority need, or not any case law I've seen, just to quantify that. And actually, these conditions still affect me. Again, bringing up the disability and stuff, and sort of just starting from scratch almost. But yeah, sorry, Will.
I would say that the thing that's worrying me here is that there's a process that councils are supposed to follow in dealing with a homeless application. So they make inquiries and then they provide a written decision as to whether the person is entitled to what their entitlement is. And also, to go back to what I was saying before, they'd have to draw up a personal housing plan. Now, it's difficult to know. The worst case scenario of what's going on here is that he's just been advised sort of anecdotally on the phone or in person, there's nothing really we can do for you, but if you find somewhere yourself, we can help you with the deposit. And that suggests that they haven't really processed the application at all. It may be that there has been a decision letter and a personal housing plan, but it's just not mentioned here, but it sounds like it hasn't. So that would be a grounds for making a complaint. Because, and also I would say, I mean, you've both said it, I think that people shouldn't think that mental health isn't as important, well, isn't important in giving rise to priority need and vulnerability, just because it's not, you haven't got a crutch and a plaster on your leg doesn't mean that you haven't got a health problem. So those are my comments there. Just complain about the lack of a personal housing plan and what sounds like a lack of a Section 184 notice.
Yeah, I mean, so my experience of making complaints in a situation like that is you would probably get a couple of £100 at the end of it. So the fact that say a personalised housing plan hasn't been issued and there hasn't been clarity, then the LGO would award compensation for the kind of the uncertainty and stress that caused. But if there wasn't going to be a duty to house them in temporary accommodation or something because there's no evidence that they meet the threshold to be housed that way, then they wouldn't get compensation for that kind of element of it. So I mean, there's nothing to lose other than your time by making a complaint. But I think really, I'm kind of multitasking, so I'm not 100% paying attention to what Shannon and Will are saying. I'm sure it's awesome, but yeah, I think just kind of there needs to be some evidence. You need to get some evidence of being in priority need or potentially being in priority need. Otherwise, I don't think that kind of the council's going to really help you that much. So yeah, that's what I'd say about that one.
Just really quickly as well, I just had a thought. If the person is working, now look, not every person with mental health has time off because of their mental health, and not every person with mental health who's working tells their employer that they've got mental health issues. But potentially this person does have a really good relationship with their boss and actually is quite open about their sort of health issues, which personally I recommend, because it makes things easier down the line if you do need time off. But there's potentially something the employer can do here and say, actually, look, this person does work for me. Actually, they really struggle with X, Y, and Z. This is how their mental health affects them. And again, it's not ever going to be as weighty as a GP's letter or anything like that, but it's just another sort of outside source potentially helping you. And that's in your employer's interest as well, because you're going to be a worse employee if you're homeless. So yeah, I'd maybe explore that avenue as well. It's difficult to get GP appointments at the best of times, let alone when you're working, potentially 9 till 5. When do you go to the doctors? So potentially approaching your employer might be a way to sort of try and get some of that medical evidence.
I agree. Can I give an example of why that's a really good idea? Is that I used to get a lot of cases. I don't seem to. I'll probably get one tomorrow, but I haven't had one for a while, where people were wanting to turn down accommodation because it was very high up in a flat, and they said, "I've got a fear of heights." And so when you ask somebody, "Have you got any medical evidence?" the answer is no, because you don't think of a fear of heights as being a medical condition. It is, but it's not something you can go and get fear of heights medicine for, and then you can sort of look, you can live on the 50th floor. So the problem was the GP would say, well, I don't know if he's got a fear of heights. He's never mentioned it to me. I could get a psychiatrist to prepare a report and say, yes, I believe this person has, but writing to an employer and saying I remember that when this person started working, they couldn't go above, we had to make arrangements so they could only stay on the ground floor because they couldn't go upstairs because they had a fear of heights. Then you've got some evidence there. And it doesn't have to be medical evidence, because a doctor who's diagnosing somebody with a fear of heights, the council may take it with a pinch of salt and say, well, they're just saying it to be helpful, but they probably never, the medical records probably never show any engagement with it. But an employer is a really good witness to that. It worked in that case as well. They said, okay, we accept it.
Yeah, and I think on a similar line, I guess, I mean, I'm not saying this would be relevant to this situation, but if occupational health has been involved at some point, then potentially their assessment and their kind of, they would actually be very detailed. It would equally hold some weight. So yeah, as I say, I mean, yeah, I think, as I say, my takeaway from this question would be, you really need to kind of bolster the evidence you've got about being vulnerable. Because that, making a fresh application, it's going to hinge on that really. Otherwise, you're just going to get the same thing again. Council will, even if they follow the law, they'll engage with the relief duty, they'll do a personalised housing plan, and they'll, waive £850 at you, and that'll be it. And then it will, the relief duty will end again. Cool. Next question. This come from the live chat now, so we're on to the live chat. So just registered as in danger of being made homeless. I was given prevention duty in a personalised housing plan, but now I'm being told to reach out to hostels and almshouses, but the hostels say it should be the council making those appointments. So a couple of things going on here. So councils are absolutely at liberty to tell you, about the options that might be available in terms of supported accommodation and hostels and whatever. But what they can't say is that's going to be your only option. What they can say is, you've got some health issues, you might be in priority need, so that might result in a main housing duty being given or whatever. But yeah, either way, you should be exploring other options. So you should be looking into other, supported accommodation and so on. They can say that, they just can't give you the impression it's your only option. But then in terms of, it sounds like this person's then approached hostels who've then said, oh, the council need to make the referral. So that will depend on the individual hostel. Some hostels you can apply directly. Some hostels you need to have a referral from another agency. So you might just need to go back to the council and say, look, I'm under prevention duty. You've told me to go and consider supported accommodation. I've done that, and they told me I can't self-refer. So what are you going to do about it? And get the council to make the referral. So that's kind of how I'd potentially deal with that one. I haven't got anything else to say about that one, guys. Do you want to chip in at all, guys?
I'd just say, this is where I think potentially doing things in writing via email is actually really useful, because otherwise it can get this phone call, he said, she said. Whereas actually, if you email a supported housing provider, they reply saying, no worries, but we need the local authority to refer you to us. And then you just forward that to your housing officer saying, hiya, I've made inquiries. This is what they've said. Please, can you help me out? It's actually a really non-confrontational, sort of easy way to just point out that, not that what you're saying is true, but I think there is a lot of disbelief around this sort of stuff, because then they go, oh, well, that's not how it's worked, or so-and-so there accepts them and so-and-so doesn't, because unfortunately there doesn't, within the supported housing structure and system, there isn't often a lot of consistency. So I just think it highlights perhaps one of those times where actually putting things in emails and having things in writing is really useful, and it also shows that you're cooperating. But again, like you say, you obviously don't have to go down this route. There are potentially other options for you.
Mike, can I add to this? This is another one where it sounds a bit like the council aren't following the process properly. And as a lawyer, obviously, I'm obsessed with process, but it's there for a really good reason. The reason that councils are supposed to put things in writing is because the danger is if they didn't, they could just get away with giving you a load of old flannel, and then you'd never know what they'd actually said because they're the only ones with a record of it. So here is a good example. So he's given I'm taking it so the person is given a prevention duty and a personal housing plan. Now, my understanding of personal housing, a prevention duty is where they say, well, we think your place is okay for you, but there's a risk that the landlord seems to want to get you out, and we'll try and negotiate or help you to do things. Maybe we'll give you a back payment of a discretionary housing payment so you can clear some rent arrears or something like that. But the thing is, if they're advising the person to reach out to hostels and almshouses, that suggests that they've gone beyond prevention and they're now sort of acknowledging that they may be homeless or at risk of homelessness, which they're not able to prevent. And that's why a Section 184 notice is important, because if it appears they've issued one saying, yes, you've got a prevention duty, but now they really ought to recognise that that's failed, because they're advising to reach out to almshouses. So they should be accepting a relief duty now and then coming up with a plan based on that. But they don't seem to have done that. So I'd complain about that.
So I'm interested by that, Will, because I would have thought that the work of, so say someone's in prevention duty and it's likely they're going to become homeless in 56 days. I would have thought that it's still possible for the council to advise you to go and explore supported accommodation options, with the hope that, should everything else fail and you actually become homeless, the application process to the hostels would have already started, and so you effectively save a bit of time. So as I say, I'm not. My experience of casework is it doesn't really, the prevention duty doesn't really matter anyway, because it just doesn't really do anything useful.
No, although I think it can be made into a more powerful weapon than people realise, because if you're ever dealing with somebody that is facing eviction, probably not by the same council, but by a housing association, say, you could, and they've got a load of rent arrears and bits and pieces, you could say to the council, please, can you help this person? And then you could say to the court, the council are taking steps to look into assisting them in preventing homelessness. Can you adjourn the possession proceedings while this is going on? But I just think here that they seem to have moved beyond prevention, and they're looking at actually acknowledging this person's going to need to be rehoused. But it may be, you're right, they could be just giving helpful advice that, by the way, if we're not able to prevent homelessness, you might want to do this. But I can't quite see the point of going to a hostel if you don't need to, because the council have prevented you from needing to.
Yeah, I mean, yeah, but would so say the council successful, they referred you to the hostel within the prevention duty. You went to the interview, the hostel accepted you, and then you moved from your current accommodation, which you were going to lose anyway, into a hostel. Would they? I would have thought that they would count that as a prevention, because you never actually became homeless. So just, I mean, as you say, it's pedantic, isn't it? But it's
in the general sense of the word prevention. I mean, any involvement, any step by local authority in discharging a homeless duty prevents somebody from being homeless, I suppose. But my view is that once you're actually helping somebody move to somewhere else, you're rehousing them, and that's not the same as, I may be getting this wrong, but prevention seems to me to be to enable somebody to remain where they are at the time of presenting. And because I think the politicians were upset about the idea of saying wait till the bailiffs come, not just because it's bad for the applicant, but also because there might have been an opportunity with a bit of effort from the council to stop the person becoming homeless in the first place.
Yeah.
So the person has just added to this. I think it's the same person. Yeah. I'm classed as a lodger. They spoke to the landlord, and except I will be homeless in 56 days, I had to sign something when I met the housing officers.
This is the
Okay.
same person.
Yeah, the same
Yeah,
person.
yes, I think
Right,
it is.
sorry,
Yeah,
sorry.
yeah. So lodgers don't have the same. They don't enjoy the same security of kind of tenure as a tenant. So so in theory, I guess if I understand it, and go, you guys might correct me, but a living landlord could basically tell someone to tell a lodger to leave immediately. Is my understanding of it.
Yep. You
So
got no
so there's
security.
yes, there's no kind of court process for that. So yeah, so they've obviously spoke to the living landlord who said, yeah, I'm going to kick them out within 56 days. So the prevention duties kicked in for that reason. So I think, yeah, and I think again, it's going to someone in this situation. It's all again going to come down to priority needs, because if you're in priority needs, you can be confident you'll get some kind of offer from the council through the homeless application process. And just to dovetail this question with another question that's kind of on the same issue, if you're not in priority need, the council, legally should assess your case under Section 189A, go through the Section 189B relief duty, and kind of try their hardest to try and help you find housing. But if they fail to do that and you haven't found anywhere, then that duty will then end. But if you're in priority need, it's very different, because they're then motivated to actually genuinely help you by giving you a final accommodation offer or a final Part 6 offer in the relief period, because it then gets you off their books and it gets you out of TA and it's better. So that's kind of why priority need becomes so important now. So yeah, so someone's on PIP, lower rate. So I think priority need is definitely in play. It will just again depend on the facts of the case. There's just, I think there's, as I said, let me just copy and paste that question in there, so it's kind of so we just kind of keep track of it all. So as I say, I probably wasn't very helpful to amalgamate two questions there, but that's kind of what we're talking about. So, and again, I'll just go back and add some bits into the other question. I've just realised as well, yeah, good, just a reminder to pick up on it, but just please ask questions as if they're about someone else. It just makes my life easier as well. So there's one other question, but I need just someone asking about being housed away from their GP and kind of needing a taxi, which is 17 quid each way. I'm assuming that question is asking about someone who's been placed in temporary accommodation rather than it just being their own home and they can't get to the GP. Now, in a situation like that, so if that is the case, so if you've been placed in temporary accommodation and you have some essential healthcare stuff that you need to get to and you don't have the money for, you can certainly raise that with the council. And I'm sure every council does it differently, and I'm not quite sure which bit of the law you're drawing on, but certainly my experience at Bedford Borough Council is if you tell them that's what's happening, they will pay for taxi fares as much as necessary. And I've even heard of councils actually going well over that and actually wasting a lot of money, because for example, they'll pay for someone's taxi fare to come and pick up their meds every day, and actually what could happen is the prescription just gets changed so that they have a closer pharmacy. But yeah, so that's what I'd be doing there is I'd be writing back to the council and saying, this is my situation. I need to be at the GP for fortnightly meetings or whatever, and I can't afford to get there. Can't get there in terms of can't walk there. There's no pavement or whatever. What are you going to do? That's essentially because I guess the legal bit comes from the fact that any accommodation the council offer has to be suitable, and that takes into account location and access to services and so on. So that's maybe where you'd kind of the bit of the law that you'd actually be basing it on. So yeah, you guys want to add anything to that one?
Just really quick, it might be worth applying for PIP. And it obviously depends on the medical condition, or how it's affecting you and stuff. But PIP in part is supposed to be designed to cover those costs of taxis to and from GP appointments, and there's obviously an assessment time, and what have you. But it might be worth starting that ball rolling, particularly if this is looking like it's going to be a long-term situation. Might have other costs as well.
We're going to go back and sorry, I'm not meaning to ignore that person's question, number 6, but number 5, I was just looking up the case law on that. Because I think that's a really good question, isn't it? Number 5, can they at the end of the 56 days, can they say, well, we tried to help you, so sorry we didn't manage to do it. So nice knowing you, and wash their hands. What do you guys think?
Yeah, so basically, I'll bring it up. So in the code of guidance, I'm just again trying to find it all. I look like such a goof. Here we go. It's right. Now I can now see it. It wasn't even my fault that time. So if we go down to chapter 14 of the code of guidance, it basically lists all the different ways that the prevention and relief duties can end. And it's a nightmare of a chapter in terms of, it took me ages to work out what it's even talking about. But basically, somewhere. So oh man. So yeah. So B. So this is prevention and relief duty would end where the housing authorities complied with the prevention or relief duty, as in they've tried their best to house you, and 56 days have passed, regardless of whether the applicant is still threatened with homelessness in the case of prevention duty or whether they have secured accommodation in the case of relief duty. So even if they haven't, so it's basically irrelevant. If you haven't secured accommodation in the relief duty and the council complied with their reasonable steps they were supposed to take, which might not extend to very much, then the relief duty would end, and then that's the end of it. There is no further offer as far as I understand. So again, and it does give some more detail about that in terms of, I'm trying to see if there's pick anything else out. Let me just zoom in a bit as well so you guys can see it, because it's not very clear, is it? And it does say the council can continue to deliver the prevention or relief duty with any applicant longer than 56 days, as long as no other duties take precedence. So it's open for the council to extend it. Where the housing authority satisfied the applicant has a priority need, and yeah, so that's when that again, yeah, that's why priority need matters so much. And council shouldn't have a blanket policy for ending after 56 days. But essentially, that's really it, really, as far as I can tell. Again, I'm just scanning it here, so I might be missing something. But that, as I understand it, is where within the law it talks about, the fact that if the relief duty ends, you're not in priority needs. Council complied with their bits. That's the end of the road for your homeless application, unless your circumstances change and you and you can make a fresh application because you might now be more vulnerable or something. That would be it. So yeah, as I say, it takes a bit of time to digest that fully, but that's my understanding of that question. Will around the fact it doesn't have any teeth, in my opinion. I know you're saying it does. I know you're saying that if you kind of make sure the PHB's been done properly, if you make sure the assessment's been done properly, then there would be kind of some teeth within it. But I think actually, if you're not in priority need, I just don't know that it's going to be any use to you, unless the council's been nice, which does happen, believe it or not. But yeah, I don't know. Yeah, I don't know. As I say, feel free to kind of raise that again. Someone's just put in a couple of questions which aren't actually questions. So just someone saying about family bidding since 2018 and now on band 2, and the council's refused 2 school letters. What I'm assuming they're talking, I don't know, I'm not quite sure what the question is there. So I'm going to leave that for a little bit just for the person to come back and say what the question is. And then there's a question here which is maybe a little bit too specific for me to actually give a good answer to, because it's asking about a particular thing in Wandsworth, which I don't have any experience in at all. Will might do. But so how does bridge housing work? As Wandsworth Council has referred me to them. I'm currently in temporary accommodation. My guess would be with that is that it's supported accommodation. It's a charity or something like YMCA or St Mungo's or something. We could probably Google it actually. So that would be my guess. So they owe you some kind of duty. They have referred you to support accommodation as well. So let me give you an example of how this works out. So a guy I worked with a few years ago, he was a victim of modern slavery and had some pretty significant mental health issues and physical health issues. So I knew from day one he was going to be in priority need, made the homeless application, the council accepted the relief duty, and the housing officer, who was an absolute moron, basically just told them that they didn't give him any certainty. They said, I've referred you to the local mental health unit, supported accommodation, because you've got a diagnosis of depression or whatever it was. And I said to the guy, look, if you don't accept, if you don't engage with that referral and just wait for the relief duty to end, then they're going to owe you the main housing duty because you're clearly in priority need. and that's what he did, and that's what happened. So he ended up in social housing. So if he'd not been in priority need, and if I'd not been very sure he was in priority need because it was really obvious, then I would not have told him that that's the situation. But you know, so that's why priority need will make or break this. If you're not in priority need, or if you don't think you're going to be found in priority need, then you know you need to engage with whichever best options you can get hold of. So if supported accommodation is your best option, like bridge housing, I'm assuming that's what it is, then you just need to engage with that referral. But if you think, oh, sorry, Shannon's shaking her head. What do you think it is, Shannon?
So from my Google, bridge housing basically is like a housing register system. So bridge housing work with social, like housing associations, social housing, local authorities, charities to find people accommodation. They're almost like an agency for accommodation, which is such a weird concept to me because how are even more people making money anyway? But yeah, so they seem to be someone that the local authority refers to. You apply on their register, and then essentially, I'm assuming it will be a similar sort of you bid for properties, or they put you forward for properties, to get a form of housing through them.
So it might be because Northants use a system called Keyways. A lot of councils, their housing register is called something else, but it's actually kind of in house. So yeah, it might be kind of a kind of an amalgamation of that sort of thing. So I think. Yeah, so if that's the case, if it is just the gateway to other housing options, then it's no bad thing. It might just be the standard route for someone who's in priority need in Wandsworth Council. It just depends on the locality there. So yeah, right. I've asked for a bit of clarification from that person, but not had it yet. We haven't got any other questions yet, and it's approaching 8:30. So last orders for any further questions, unless I've missed one.
So while you're waiting for that, can I just come back on that 56 days question? Because I've just been looking at the case law. Now, it is in this case of Perrott, which I was talking about before. And if you look, so the answer to the question, can they simply say 56 days have gone by and we haven't found anything? Sorry. The answer is no, they can't. And not necessarily, because if you look at the circumstances where you can discharge, where the relief duty can come to an end. And sorry if I'm getting very lawyerly, but it's in section 189B(7). I think. Hang on, maybe it's not 7. Yes, it's 7. It says the circumstances are that the authority are satisfied that, and then you can. One of them would be that you've got accommodation. I won't go through them all, but the one about the 56 days is number B. Or letter B, and that says the authority have complied with their duty under subsection 2 and 56 days has gone past. So it's not just 56 days have gone past, they've got to have complied with this duty under subsection 2. And you may say, what is that duty under subsection 2? And it's the duty to take reasonable steps to help the applicant find accommodation. Now, you may say, well, that's a bit circular, because they'll say, yeah, we've taken reasonable steps. But unless they've done a proper assessment and drawn up a proper housing plan, which you can show to a judge and the judge will say, yeah, that's pretty good. The 56 days doesn't allow them to end it. And that's what happened in Perrott. They hadn't done a proper assessment and they given a section 184 notice saying, sorry, the 56 days is up. And even Hackney's lawyer, I mean, Hackney in court had to accept that wasn't, they didn't, when they were having to say, we didn't really mean that. What we meant was, we've taken reasonable steps but they were so used to being able, they thought they could get away with that, but they couldn't. And it was found that they hadn't taken reasonable steps and the duty hadn't ended.
So explain that to me again, Will.
Yeah,
sorry. No, it's good. So let me repeat back what I think you just said, and then you can tell me if I'm wrong or not. So for a council to end the relief duty without the person being housed, they would need to have done the assessment properly, would need to have set out a decent personalised housing plan, which genuinely had reasonable steps within it, which would, kind of be helpful, which I'd still say fall short of actually, kind of being enough necessary to find them housing. And if they have done all of that and 56 days has now passed, they could legitimately end the relief duty without the person being housed. Is that what you just said?
Yes.
Yeah. Right. Okay.
So
Okay.
it's they've got to have taken reasonable steps, and the reasonable steps, and it's not just giving.
Or you got to mute.
Sorry,
Will, hold
sorry,
on.
I'm getting some noise in the background. It's not just giving somebody some leaflets, it's also assessing their needs and then taking steps to actually meet those needs and draw up a proper plan. And judges are particularly interested in whether they've done that or not, because that's the sort of thing they look for. Because that's what the personal housing plan is designed for. It's almost universally ignored and just treated as something that you print off the word processor that's got nothing in it. But you could challenge it. I'd go a stage further, and I won't go too much further, but I think that in reality, a local authority, if the person is still homeless at the end of the 56 days, common sense says, well, they haven't done very much. They haven't taken very many reasonable steps to help them find accommodation. The only way that would be reasonable if there really isn't any. And we know that local authorities have a stock of private accommodation because they discharge the full duty into private sector accommodation. So for them to say, oh, sorry, there's nothing around, it means that they're probably ring fencing accommodation. I think one day somebody will challenge that and say, well, you're sitting on all that private accommodation and you couldn't help the person get hold of that. So I think there's still a lot of fighting to be done over the relief duty.
I mean,
It
I'd
shouldn't be
obviously
allowed to
welcome.
lapse.
Yeah, I'd obviously welcome if that was successful. I just think that, so let's say they do a thorough assessment, they do a thorough PHP, and in the PHP it says, if we come across any vacant private properties, we'll help you into it. And if you go and find a private property, we'll pay £850 for you to help move into it. But even then, we know that, that in the private renter sector, it's still very unlikely that that's going to be successful. But I'd say, that I guess, you've kind of said before multiple times, this word reasonable for a lawyer it's very elastic. It kind of, you can use it however you want, really. And I fear that that kind of, what is a reasonable step? Well, if the local authority says, well, we don't have any landlords going spare, then, that's not reasonable to try and offer it. I think they would maybe argue that. But, I'm just saying, I'm not trying to poo-poo it. I just think.
I think it would be useful because for Freedom of Information Act questions to find out for local authorities to what extent are they because we know that they have a stock of private sector accommodation available to them, and they have landlords that they've been recruiting so that they can discharge people into private sector accommodation. So they know that there are empty properties available because they're using them to house other people. So it'll be interesting to know, but I mean, they will say if you ask them, oh, well, that's not for you, that's for people that we've accepted a full duty to.
But then, because I was thinking, you literally took the words out of my mouth. I was like, there's some sort of FOI there that could be done. But do you know the bit in where someone who's made a Part 7 application has to have reasonable preference and given sort of like bump up as you like? Does that exclude the people we're talking about? Because if so, then the council could reasonably say, well, actually, yeah, we have ring fenced it because they are supposed to have reasonable preference and you don't. Or would it include that? Because I can't remember. I'm really sorry. I'm having a bit of a night tonight, apparently. But would it include them or not?
Well, I don't think that would necessarily. I mean, there might be a policy. They might be able to come up with a lawful policy that allows them to exclude people who aren't in priority need from getting hold of private sector accommodation through them. But I mean, I struggle to see how they could do it and come up with this thing, say, oh no, there's no private sector accommodation available, when they know full well that there is. But they're just choosing not to give it to people. But I'm one of these days I will try and do. I mean, if you're thinking of freedom of information questions to ask, I'd be really interested to add that one to the list of what are your criteria for. Are there any circumstances in which you would consider making a direct referral of somebody to a private landlord under the relief duty as a way of helping them?
I mean, I think you're right. It certainly happens. I just think it only happens when it suits the council. So,
Yeah.
first of all the people in temporary accommodation, the council would want to clear them out into private rented accommodation before they start giving it to people they don't have that duty to. But yes, I think I said a few weeks ago, my experience of working in Bedford is if a landlord offered a property on 9 o'clock Monday morning and there was no one who was going to make a good tenant in the eyes of the housing officers, and if they didn't put a tenant forward for that property ASAP, then they'd lose the landlord. Then if I've seen people walking off the streets and happen to ask, "Oh, can you help me out with housing?" There's no priority need or anything, and the council are like, "Yeah, sure, we've got something just come available," but it's very much kind of random, and there's specifically no waiting list. They're very careful not to have waiting lists. So yeah, we can certainly talk more about how you would kind of create that FOI to get what you want. And just in terms of Shannon's point, so yeah, the reason if you owed the prevention duty or the relief duty, you get what's called reasonable preference. And again, I would argue that what councils would say was, well, we took reasonable steps. We gave them reasonable preference on the housing list, and that was band D, and it had no prospect of actually getting them housed. But I think that's kind of how they would try. But yeah, as I say, I'm not. Yeah, don't get me wrong. I'd love to see a case which gave the relief duty more teeth. I just think it kind of lacks it. But yeah, no, I absolutely take what you're saying, Will. In terms of, I think it's very difficult to expect people who are in the middle of being homeless to kind of get their heads around that. But certainly for professionals, I think this seems to be a battleground which actually would potentially be plausible to actually get better outcomes just by making subject access requests, checking out how useful the assessment is and how useful the PHP is. That in itself would probably lead to better results overall. So someone's just asked, I'm not going to put this into the questions, but someone just asked about what I was just searching there. So basically, on if you search section 189A, you can search any section you want. So if you just put it in Google, section 189A Housing Act, it will come up. Equally, if you put section 184 Housing Act, again, it will just come up. So that's what I was just looking at there, where I went through it. So section 189A and section 189B are all about the relief duty, which, as we've seen, is nothing else if it's not complicated. So, and someone just asked there again, I'll put this on the chat. So are there samples of personalised housing plans templates available anywhere online? Yes, there are. So if you, I think, if you Google, let me just do it. Let's do it together. Hold on. So if, let's just, right, hold on. Share the right screen, Mike. There we go. So this was the housing act shared. So if we just Google Andy Gale templates. So we have this Andy Gale's a well-known person in the homeless sector, and I'm pretty sure these are available for free. So this is his website. I am not a fan of Andy Gale, just to say that, but certainly if you sign up, you can get a lot of free stuff. I don't know if it extends to template personalised housing plans, but there's something like 155 template letters that you can get. So as I say, feel free to check that out if you want. You can also FOI the templates that your council use. So we did it a few years ago. We templated, we FOI'd the non-priority decision template, and I did a video just picking it apart because it was garbage. So it's interesting, and if you ever wonder why housing officers make stupid decisions, partly it's because they're using stupid templates. So yeah, as I say, you might find it interesting. But I'm not quite sure. Yeah, it's good. It's good to understand how these letters are written, because when you get a letter from a housing officer, they're all written in legalese, and you think, "Truth, this guy knows what they're talking about," and they really don't. They're just putting words in boxes, and it does it automatically. Okay, guys, right, we've got no more questions. We'll call it a night there, unless any Shannon or Will have got any final thoughts. If not, you guys around next week, Thursday?
I might not be because it's half term, but I might be because I might be able to squeeze it in.
Yeah. Okay. Cool. Well. Yeah. So some of us will be. We just celebrated our first birthday, by the way. Live stream first birthday. Just went, went past. Should have got cake. Anyway. So yeah, guys. Hopefully that's all been. Yeah. Hopefully that's all helpful. We'll see you in a week's time, and keep going. Basically, I think that's the message. Don't stop complaining. Don't stop. Don't give up.